jurisdiction. That's where cross-border insolvency comes in. Now, Malaysia is now stepping into this space with the proposed Cross-Border Insolvency Bill 2025. What does this mean for businesses, creditors, and the economy? This is Money Matters. Hello and good evening. You're tuned into TV3. We are also available for you to stream on Tonton. I'm Azaria Tagaya, and as promised earlier, today we're talking about cross-border insolvency and how this development will actually help us in aligning the country's insolvency framework with international standards. Now, joining us to unpack all of this today are two very important people. They actually led the team in making the cross-border insolvency bill a success and a realization. So our first guest is the Deputy Director General for Law Reforms at the Prime Minister's Department Legal Affairs Division, Thiagu Ganesan. Welcome.
Thank you. Thank you for having us today.
Thank you so much. And next to Thiagu, we also have the Head of Policy and Legal Division at the Malaysia Department of Insolvency, Azniza Muhammad Ali. Thank you. Welcome to the show.
Thank you.
Thank you. It's a pleasure to have both of you with us here today. But Thiagu, let's start with you now. Let's begin with the basics. What exactly is cross-border insolvency? And tell us about the bill. Why is it being introduced this year? And why is it important?
It is a simple question, inviting for a long answer. I mean, practically, theoretically, they are important concepts for us to understand. Firstly, what is insolvency? Second, what is cross-border insolvency? Let's start with what is insolvency. Insolvency simply means when a company unable to pay its debts. In Malaysian context, if a company owes Ringgit Malaysia 50,000 and fails to pay that particular amount, it then may trigger insolvency proceeding or other rescue mechanism such as corporate voluntary arrangement and also scheme of arrangement. What happens in insolvency proceeding? Insolvency proceeding, where a company is wound up, the entire assets will be vested upon a private liquidator or vested upon Director General of Insolvency, being the official receiver, to trace back the asset, realize the asset, and pay off the dividends to the creditors if there is money. That's a liquidation process. So basically, that is what insolvency means. Next, what is cross-border insolvency? Cross-border insolvency occurs when a company has assets or creditors or operation more than one country. Meaning to say that whenever the company has assets abroad and businesses abroad, there need to certain procedures to be in place to coordinate the proceeding between two countries. That is called cross-border insolvency.
Okay.
This particular bill have 5 primary objectives, which we have listed in the blue bill itself. Number 1 is the cooperation between the courts and also the other competent authorities in insolvency cases. So it's provide for the cooperation of the courts. Number 2, it is actually ensure fair and efficient administration of the insolvency cases that protect the interests of the creditors, other related person. Number 3, a greater legal certainty. By having this law in our country, we have greater certainty for the trade and investment. Number 4, it is actually to protect and maximization of the value of the asset. And lastly, to facilitate the rescue of the business, financial distress entities. Thereby, it will protect the investment and also preserving the employment. Primarily, that is the objective. But why now? Why now? It is important question because our Right Honourable Prime Minister, Dato Sri Anwar Ibrahim, and our Minister, Dato Sri Azalin Atman Said, supported by the Minister of Domestic Trade and Cost of Living, they wanted to do reform in a commercial area where attract businesses, where attract investment to come into our country. And that will make our economy very competitive, generate income for the country and for our people. So technically, to answer cross-border insolvency legislation, to send a strong message outside there, our commercial law is in line with the global best practices and to attract more businesses coming into our country.
All right, wonderful. Now, moving on to you, Azniza, I believe that this bill is actually modeled after the United Nations Commission on Trade Law, or UNCITRAL model. So why is this important, and why did you use this as a foundation when coming up with our own legislation?
Yeah. It was enacted in 1987 by the United Nations Commission on International Trade Law, UNCITRAL, and it is a very comprehensive legal framework providing guidelines for countries to manage cross-border insolvency, and it serves as a blueprint for those countries in managing insolvency, cross-border insolvency effectively. So what are the principles enshrined in the bill? There are 4 principles altogether. First is access, how we allow or grant access to foreign representatives coming to our country. Next is recognition. What are the cases that our courts will recognize? What are the positions of these foreign creditors and foreign representatives? The third principle is relief, what sorts of relief that our courts can grant to these businesses, distressed businesses experiencing financial difficulties. So on top of that, we have this line of 3 C's, communication, cooperation, and coordination. So how these multiple proceedings taking place in cross jurisdictions being administered or managed effectively. And we look at the primary objective of this law. It is to enhance cooperation and communication between courts and also insolvency representatives. And why this law? Malaysia's decision to adopt the model law is vital for its economic and also for its legal framework. We are relying on committee principle. So it is a non-binding legal doctrine in which it is done out of courtesy or respect when one court recognizes recognition, when one court recognizes decisions or insolvency proceedings in another court, but there is no legal certainty there. So why this law? Because it provides legal certainty to support modern business practices, and it definitely it will enhance creditors, investors, like what has been explained by Mr. Tiago, and we can see that now we have 60 countries who have adopted the law. These include United Kingdom, New Zealand, Singapore, the United States, Japan. So these are developed countries. So what I'm going to say is that Malaysia is aligning its corporate insolvency law with best practices.
All right. Now, it's interesting to see how you mentioned that we actually have to align with foreign insolvency proceedings. So it would be interesting to find out how the courts are going to deal with that. But hold that thought. We'll be coming back to that after the break. Right now, we're going for a short breather. Don't go anywhere. Money Matters. We'll be back after this. With us. Thanks for staying with us on Money Matters. We're talking about the cross-border insolvency bill with our 2 very important guests in the studio. Now, Tiago, I'd like to get back to you. Before the break, we talked about how these legal proceedings will actually affect the Malaysian courts. And I also want to find out that while the bill opens the doors to foreign claims, how does it actually ensure that our local creditors are also protected at the same time?
Let me explain the important terms that been inserted under this cross-border insolvency legislation. First, foreign proceedings, main non-proceedings, and non-main proceedings, and also establishment. And there is no term for commie. However, there is a reference under section 16 sub 3, where in absence of any contrary, the register address of the debtor will be presumed to be the center of main interest, because this is very important element to determine where is the main proceeding will be occur. So that is the main concepts of the proceedings. Now we move on. What are the safeguards been provided under these particular legislations? Before I go into the safeguards, allow me to share also, there are circumstances where the creditors will get the same treatment. This has been stated under Article 13 of UNCITRAL Model Law. This has been adopted under our legislation as well. And the priority list under Section 527 of the Companies Act is not been changed. Remain there. That will also protect the creditors' interests. So now coming back to answer the question, what are the safeguards in place to protect the creditors' rights, the creditors' interests? There are 5 safeguards, if I may. Number 1, actually, we have Clause 3 sub 2, where the Clause 3 sub 2s have given exemption to the certain entities to have effect. This particular law will not applicable for them. This is why, because to ensure that entities have their own insolvency mechanism to follow the respective legislation. And also we have Part 2 and Part 1 under the schedule also have given certain exemptions where the court will exercise that power. That is number 1 safeguard. Number 2, we have also Clause 4 that says that this particular legislation has to be read together with the other legislation that exists in this country. This means that this particular law has to be comply with the other legislations that already been passed by the Parliament that has been enforced in this country. Number 3, there is specifically there is a Clause 7 has been provided that no recognition, no relief, no cooperation. The court can refuse those requests if it is contrary to public policy. That has been inserted in the legislation as well. Number 4, if I may to share, there's a specific provision has been inserted under the Clause 21 sub 2 and Clause 21 sub 3, where if the foreign creditors, foreign representative want to extract, to move out the assets from our country, they have to obtain leave from our Malaysian court first. And there is a statutory threshold to reserve certain sum for the benefit of the local creditors. The last safeguards is that the Clause 22, where the general power has been given to the court also to deny the relief or recognition if it after consider upon the interests of the creditors, unsecured creditors, secured creditors, and other related parties, including the debtors and etc. By doing so, the court truly evaluate the circumstances entirely. Coming back to this legislation, primarily provided for the 4 important steps which Puan Azniza shared with us earlier, that access to provide recognition, relief, and also lastly coordinate and cooperate. So these 4 principles works harmoniously in a procedural manner under this legislation. At the same time, the safeguard in place to protect the creditors' interests as well.
Well, picking up on what you said just now, also I'd like to ask Azniza. Now, under the bill, foreign representatives will now be able to apply for recognition in Malaysian courts. So what type of proceedings are covered under the bill, and what does the whole process actually look like for foreign representatives?
Yes. So the question refers to the types of proceeding that our courts can recognize. So our court would not recognize all proceedings that being applied by the foreign representative. So the bill outlines 4 elements. The first one, definitely, the proceeding it must be confined to proceeding relating to insolvency law for obvious reasons. We are dealing with cross-border insolvency, where dealing with the affairs of distressed companies. Next, the proceeding must be for the purpose of reorganization of business or liquidation. What is reorganization of business? This is where the corporate rescue mechanism takes place. Viable businesses will be rescued if we can still help to protect employment, safeguard stakeholders' interests, and also the interests of the company itself. But how about liquidation? This is the process where, in the easiest way to say that is, companies cannot be safe anymore. So the third element, the proceeding that we want to recognize, is a collective proceeding. So what is a collective proceeding? It refers to a proceeding that is brought for the benefit of all parties. We are taking into account the interests of the creditors, stakeholders, the shareholders, the company itself. So this can be differentiated with non-collective proceeding. For instance, I give you an example of receivership. So it caters to a specified group of creditors. So that is not a collective proceeding. And next, it must be a court-controlled proceeding, which means that it must be supervised by the foreign court. So these are the elements or the types of proceedings that our court will grant recognition.
Okay.
So what is the process? First, I've spoken about the element of access. So under the bill, access is direct access. So these foreign creditors, be it the trustee or the liquidators, they always have direct access to our local courts. So what comes next is for them to apply for recognition of proceeding. And how they do it? So they have to accompany the application together with certified documents. First, they have to prove that insolvency proceeding is taking place in their country. That is called the foreign proceeding. Next, they have to prove that they have been authorized, or they are the person in charge or looking after the affairs of the company. Next, there will be a statement of other proceedings in which they would have to notify the court that whether there are other insolvency proceedings taking place in other jurisdictions. So these are the requirements that they have to comply. And it must also be noted that the recognition process is designed to be straightforward to facilitate cooperation and coordination. So, for example, if these foreign representatives cannot support their application with documents, the required documents, the court may accept other evidence. And next, the court has the right to presume the authenticity of this document without undergoing the process of legalization. And the court must promptly consider the application and determine if the proceeding is a foreign proceeding. Pending decision, definitely the court has the discretion to grant interim relief just to protect and to preserve the assets of the companies.
All right. So when it comes to legal proceedings, you also want to find out how we can ensure a fair and transparent process for all the parties involved. But it's time for us to take another short break. We'll be back after this on Money Matters talking about the cross-border insolvency bill. Don't go anywhere. Matters, thank you so much for staying with us. We're still talking about the cross-border insolvency bill with two of our guests today in the studio. Now, coming back after the break, I'd like to move to you, Azniza, and talk a little bit about how this bill can actually improve communication and cooperation between the courts in different countries. So could you explain how this will actually work and what types of mechanisms will be in place to ensure the success?
The importance of this bill is that it provides three elements which are very important to facilitate insolvency proceeding dealing with cross-border insolvency where assets and liabilities span across jurisdictions. So the first one is, like I said before, it comes with access, and then they have the three elements of the three C's: communication, cooperation, and coordination. So these are the important elements in the bill which helps communication between court to court, and this is we call court-to-court communication.
Okay.
The bill also governs communication between foreign representatives with the courts, as well as between foreign representatives and insolvency practitioners in the local insolvency practitioners. So how this will work in practice? The bill empowers the court to communicate directly, which means that we are shifting from the sending of letters, formal letters, requesting another court to help us in dealing with cross-border insolvency. So now the court can communicate directly, which means that they can always use emails, phone calls, or video conferencing. And in terms of practical side, we can always appoint a person in charge or liaison judges to deal with the communication part. And next, on document sharing. So we can use any digital platform for document sharing. And to facilitate hearing, we will have joint hearings because we are dealing with multiple insolvency proceedings across jurisdictions. There will be 3 or 4 or maybe more. So the important thing is that this bill also provides how we coordinate with the multiple proceedings taken place in different jurisdictions. So that is about communication. It's very important because one of the objectives of the bill is to enhance cooperation between courts.
That's true.
All right, wonderful. Now, once a foreign insolvency proceeding is actually recognized, the foreign representative can apply for relief in Malaysian courts. So, Tiago, could you explain to us what kind of reliefs are available under this bill, and how can we actually ensure that this process is conducted fairly and transparently for all the parties involved?
This is really important questions. Why I do say so, because this is the heart of the bill. Why I say the heart of the bill, anybody, foreign representative or local insolvency practitioners wanted to get the relief or remedy.
Yeah, this is what we're
that's
looking for.
ultimately
Yeah.
wanted. Meaning to say they can have access, they want the court to recognize, and they want the court to coordinate and cooperate. What is ultimate goal? The ultimate goal is to get relief.
Yes.
So what types of reliefs we have under this bill is the most important and the crucial one for outsiders there and the business people there. We have clause 19, we have clause 20, we have clause 21. What these clauses are speaking about. Clause 19 speak about interim relief, meaning to say, upon an application to filed for an recognition in the court, which is the IKUTI of Malaya or IKUTI of Sabah Sarawak, then the court have the power to give interim relief. What are the interim relief that the court can give? Stay of execution, and also entrusting the administration of the property, Malaysian insolvency office holder or foreign representatives, or any other reliefs the court can give. That is the interim relief. Number 2, upon court recognize the main proceeding, then clause 20 will kickstart, which is automatic relief. Before I answering with regard to the clause 20 and clause 21, there's important for us to differentiate 2 main proceedings. Initially, I alluded earlier, there is important for us to understand the key concepts. One is foreign main proceeding, foreign non-main proceeding. Why there is it's important to differentiate these 2 types of proceeding? Because ultimately that differentiate the remedy. If it is a main proceeding, then your relief will fall under the clause 20, automatic. meaning to say that only one main proceeding in the entire world. That means that particular jurisdiction will able to collect the entire asset from UK, from Australia, from New Zealand to come bring home back here the asset situated to control, take charge if it is main proceeding. So the entire jurisdiction's assets will be accumulated here. So that is the relief that provided under clause 20, namely stay of civil action, stay of enforcement, and also the other related reliefs that are provided under the law. And when it comes to clause 21, whether regardless of main proceeding or non-main proceeding, the stay can be given, stay of execution or stay of civil action, or entrusting upon the property to be placed under the foreign representative or local insolvency office holder, even ordering people to get someone for a witness and etc., or any other reliefs can be granted.
Okay, wonderful. Now, we have just a few minutes left. Perhaps I'd like to end with you, Azniza, very briefly. Now, every law comes with its own set of challenges. So what are some of the hurdles that you foresee for this bill, if any, moving forward?
The first thing to note is that insolvency administration is no longer domestic in nature. Next, we note that this bill, it introduces new concepts which are unfamiliar to our our legal system. So we have new terms or new concepts such as center of main interest. What is the difference between center of main interest to determine foreign main proceeding, and what is the difference between establishment? So these are key concepts that our practitioners need to grab. Not only our practitioners, but our judges. So what I want to highlight here is that this brings to the issue of capacity building. We need to provide training to our judges, to our legal practitioners, and also to the insolvency department. So we are the official receivers. So we no longer deal with assets domestically. So we now have to go abroad and deal with cross-border insolvency assets. So that is a new challenge to us. Apart from that, there is an issue of legislative refinement, because this law is procedural in nature. So how are we going to implement it? We need to have clear procedural rules. So there is our rules of court is in the midst of amendment. So we are amending the rules so that we can incorporate all the procedural matters to facilitate the implementation of this law.
All right. No, so it's wonderful to see how this will be able to align our legal practices with international standards. And it has been wonderful hearing from both of you. That was the Prime Minister's Department Legal Affairs Division Deputy Director General for Law Reforms, Thiagu Ganesan, and Head of Policy and Legal Division, Malaysia Department of Insolvency, Azniza Muhammad Ali, joining us on Money Matters. Thank you so much once again to both our guests today. And thank you as well for joining us for the past half hour on Money Matters. Remember, if you miss any part of today's show, you can always catch up with this episode and past episodes on Tuntun. Until next week, I'll see you again next time. I'm Azaria Tagaya signing off. Have a great weekend.